Good morning, everyone, and thank you for joining us for this Cover Talk Plus. My name is Andrew Tobin, and I'm a partner specialising in insurance and reinsurance at Mills & Reeve. I'm joined today by our associates Shaira Begum, Tim Hornby, and Charlotte Clarke. Over the next 40 minutes, we'll summarise 7 or 8 interesting cases from last year, including looking at the physical loss of goods in the context of fraud, damages for late payment of claims under the Insurance Act, COVID business interruption, subrogation, jurisdiction, and anti-suit. If you'd like to answer questions, please enter them into the question and answer box, and we'll try to answer them at the end of the session. Also, please feel free to email or call any of us directly afterwards if you prefer. Today's first case is Quadra Commodities and XL, which discusses 2 important points. The first concerns a claim for the loss of virtually non-existent goods under a marine open cargo policy in the context of a massive fraud. And the second point is of general interest to all insurers because Quadra is the first case discussing a claim for damages for late payment of a claim under the Insurance Act 2015. It's one to watch because it's listed for the Court of Appeal in the spring of this year. I'll deal with the physical loss point first and then discuss the late payment claim under the Insurance Act. The facts were that the insured, Quadra, had, or thought it had, purchased grain from the Agro Invest Group in Ukraine before the current war. Under the contract, the weight of the final quantity of grain was to be determined at the silos, which were known as elevators in the jargon. An Agro Invest subsidiary also owned the elevators. Quadra was to pay for grain in cash upon presentation of the warehouse receipts, which of course were prepared by Agro Invest as the operator of the warehouse or an Agro Invest affiliate. Unfortunately for Quadra, the vendor of the grain, and the elevator operator had perpetrated a massive fraud by issuing multiple warehouse receipts in respect of the same goods to different buyers, getting paid each time. Indeed, it seems that the value of the grain on the warehouse receipts was at least 5 or 6 times the value of the actual grain. So, of course, when it came for the goods to be delivered, there wasn't anything like enough to go around. In other words, a classic warehouse receipt fraud of the kind that London cargo insurers see all of the time. The policy covered, it was in the usual form, and covered all physical loss or damage and or losses directly caused by misappropriation to the goods. An insurer's central argument was that there was no loss of physical property here, but only a pure financial loss, which was not insured. Pausing there, I'd just like to conduct a short poll. On those facts, how many people would say that all the grain represented on the warehouse receipt should be considered physically lost so as to allow recovery under a physical loss policy? Probably a minute or two to vote. Okay, so most people think that the grain should not be considered physically lost. Some people, 40%, consider the opposite. Well, we'll see what the court decided in a moment. Reviewing the authorities, the court emphasised, helpfully, that an all-risks marine cargo insurance policy does not usually cover a situation where no goods ever existed, and therefore where no goods can have been lost or damaged. And indeed, that is cargo insurers' usual defence to these kinds of situations. But the court then went on to reach a very surprising conclusion on the main point in the case. Despite acknowledging that the warehouse receipts being relied on by the insured were unreliable, being part of the fraud, Because the evidence showed that there was at least, quote, some grain, end quote, in the warehouse, then the warehouse receipts were, quote, some evidence, end quote, of the physical existence of some goods. And that because there was not enough grain to go around, then the court was prepared to find that all of the grain represented on the warehouse receipts should be considered to have been physically taken, that an actual loss had occurred, and that insurers were therefore liable to the insured for the full value of the claim. In essence, the court allowed the insured to rely on what everyone agreed were fraudulent warehouse receipts to demonstrate the notional existence of grain, which everyone knew did not in fact exist in anything like the sums represented by the receipts. But nevertheless, on that basis, in a leap of magical thinking, the court found that all of the grain represented on the warehouse receipts had been physically lost, and that therefore insurers were liable for the whole loss. Now, if anyone is finding that hard to follow, you're not alone. To my mind, the decision flies in the face of common sense and of the usual rule that cargo insurers are only liable for the loss of things that physically existed, and not for goods that exist only on paper but not in reality, as was in fact the case here. Moreover, if the judgment was correct, then one consequence would be that everyone holding a fraudulent warehouse receipt could claim an actual loss for the amount of goods stated on the fraudulent warehouse receipt, even though there weren't enough goods to go around. So it seems that for some reason, the judge went out of his way to aid the insured. But to my mind, the decision seems completely wrong in principle and is going to lead to a lot of confusion. If the law is saying that things that never existed can be physically lost, then perhaps the law has taken a wrong turn, in my view. The case is going to the Court of Appeal in the spring, so we'll have to wait and see if they agree with the judge or with me. But the Quadra case is of more general interest to all classes of business, insurance business, because it's the first reported case to discuss a claim by an insured for damages for late payment of a claim under Section 13A of the Insurance Act. In England, until the 2015, insureds had no remedy for late payment of claims other than interest. But the Act has implied a term into every contract of insurance that, and the quote is on the slide, that insurers must pay any sums due in respect of the claim within a reasonable time. And a reasonable time includes, quote, a reasonable time to investigate and assess the claim. The claimant argued here that insurers took an excessively long time to investigate and to pay the claim. The claimant had first notified the claim to insurers in February 2019, who conducted investigations and correspondence, and declined the claim in December 2019. And the insured started proceedings in May 2020. But before we look at what the court said, I'd be interested to know how long people think is reasonable for insurers to investigate and reach a decision on a complex claim, such as this. 3, 6, 12, 18, or 24 months. Okay, so that's interesting. So about 39% think 6 months, 39% say 12 months, and only a small number of people really thinking it should take longer or less than that. And as we shall see, that's not too far off what the court found, I think. So the first question was, what was a reasonable time in which insurers should have made a coverage determination? The court found that the matter was complicated by loss location, size, missing documents, the need for investigations into the fraud, and legal proceedings in Ukraine. In other words, this is a complex matter. With that in mind, the court found that a reasonable time for assessing and paying a claim like this, had insurers elected to pay a claim like this, would have been, quote, no more than about a year, end quote. So I think that's a benchmark that is going to be perhaps used in subsequent cases, depending on if the Court of Appeal agree or not. But Section 13A4 of the Act gives insurers a defence to a claim for breach of an obligation to pay in a reasonable time where it had reasonable grounds for disputing the validity or quantum of the loss. The court considered all of the key stages of the handling of the claim and concluded that even though the insurers ultimately lost the case and had possibly been a bit slow in adjusting it, overall they took a reasonable time to adjust it and they had reasonable grounds for defending it. And so the claimant's claim for damages for late payment of its claim failed for both those reasons. Now, I don't know if the Court of Appeal will consider this particular issue. We'll have to wait and see. But for now, I think the key takeaways are that to remember that damages claims can be made against insurers now for late payment of claims. It all depends on the facts, but a period of up to a year might be a reasonable time for an insurer to complete its investigations on a complex matter, but it follows that the time taken for simple matters should be less. Insurers will have a defence to a claim like this where the declinature was reasonable, even though ultimately wrong or incorrect on the law. And insurers should expect the court to study the chronology of all the key steps in the adjustment and investigation of a claim when considering the reasonableness of insurers' behaviour, including, for example, the time taken by insurers to appoint experts, lawyers, adjusters, and so on. Our next speaker today is Shaira Begum, an associate in our Birmingham office, who'll summarise some of the key COVID BI decisions from last year. That's a huge topic and not that easy to do. But over to you, Shaira.
Thanks, Andrew. Yeah, you're right. It is a huge topic, but I am going to touch on the very busy topic of business interruption. And obviously, we all know that business interruption as a source of cover for insureds has exploded in the press since the COVID pandemic. There are, however, a number of recent cases which have emerged since the decision in the 2021 FCA test case. Of course, that case was fast-tracked to the Supreme Court on appeal, where the bench delivered their landmark judgment, which is generally viewed to have favoured policyholders. Recently, however, on 17 October last year, the High Court handed down 3 further related judgments addressing business interruption. The full citation for these cases should be on the slide now showing, but broadly speaking, all 3 cases favoured insurers. This is obviously good news, although it is worth noting that permission to appeal has been granted. We're not aware of a date for this appeal, though, so I guess it's a wait and see. I'm sure that those of you who have read the judgment in Stonegate, which is the first citation on the slide and in bold, will agree that it's not bedtime reading. It's a complex judgment, but I think equally, whilst insurers accepted collectively that their policies provided some cover to their respective insureds, albeit not to the extent claimed, the differences between their views on the extent of cover compared to those of their policyholders was stark. Nevertheless, there are some key issues which emerged, and I'm now just going to look at those. So the court was asked to consider 4 elements listed now on the slide, but I will just briefly repeat those as well. So number 1, what constituted a covered event? Number 2, aggregation. Here there's scope to argue that there were a number of separate events, claims, or losses made under the same policy. The old nutshell question emerged being, should these be treated as a single loss with 1 limit of indemnity or many losses with many limits? Number 3, causation. Whilst this topic was addressed to an extent in the FCA test case, it was addressed in a slightly different context in the Stonegate decisions, and so it is equally important and relevant to consider them again here. And finally, number 4, losses. There was a need to consider how government support in the form of furlough and business rates relief should be addressed when assessing policyholders' losses. So I'm just going to pause there for a moment and invite you all to vote using the poll that should appear on the screen and address the question of whether or not you think the government furlough relief and business rates relief should be taken into account when assessing losses under a business interruption claim. I'm just going to wait a minute or two for everyone to vote. Okay. Yeah, that's pretty good. For those of you who may not be able to see the results on screen, 90% of you voted yes, and only 10% of you voted no. So starting with that last point first, losses. From the poll result, you probably won't be surprised to hear that the judge held that based on the specific wording of these particular policies, any government support which policyholders received should be taken into account when assessing such losses. It's of course worth highlighting that these are indemnity policies and policyholders have received support from the government with no obligation to repay. Therefore, the loss has been extinguished and a payment by insurers would amount to a double recovery, and claimants may argue that that decision means that insurers benefit from a windfall at the expense of the taxpayer. So secondly, turning to what constitutes a covered event. Insurers didn't argue this point because they considered it to be obsolete given their aggregation arguments, which was in short that it didn't matter how many events there were, since the losses sustained would all aggregate together. Nevertheless, on the question of covered events, the judge accepted the claimant's arguments that each time someone infected with COVID-19 entered one of their locations under the disease wording, or that any one of their locations was forced to close because of COVID-19 under the enforced closure wording, that would be classed as a separate covered event. Therefore, it was theoretically possible for there to be multiple covered events at multiple locations. Moving on to look at aggregation now. So most, if not all of you will be familiar that aggregation is an insurance concept which governs what happens when several separate events, claims, or losses are made under the same policy. The million-dollar question is obvious. Should the losses be treated as a single loss with one limit of indemnity, or many losses and therefore many limits of indemnity? Before turning to Stonegate and the related cases, some of you might recall the Tobin and King against AXA decision of February last year. This related to denial of access wording, but the interesting focal point was again the decision around aggregation. In that case, Tobin and King successfully argued that separate limits of indemnity applied to each of the policyholders' premises, largely because of the wording of that particular policy. Again, this case is just another illustration of the specific wording of the policies in place and their overall importance. Turning to the Stonegate cases though, as you might imagine, the claimants/insureds didn't want the claims to be aggregated, but insurers did. Insurers sought to limit the number of claims on the basis that the covered events should aggregate together. So the aggregation argument I was referring to just earlier. The effect on quantum would make a significant impact either way, as the indemnity limit was 2.5 million for each and every covered event at each premise location during the policy period. The wording of the relevant clause is on the screen now, but I will read it out as well. It is worth reading out. It says, where the insured has made a business interruption claim affecting one or more insured locations that arise from or attributable to or in connection with the single occurrence, the largest applicable will apply to all business interruption losses combined. So after a lengthy debate, the judge decided that a reasonable policyholder would understand the words in connection with, which is underlined on the slide, to mean that only a relatively weak causal link is required to link losses together. This meant that a wide range of losses might fall to be connected with a single occurrence, and therefore those losses would aggregate together within a single limit of indemnity. The judge also decided that an occurrence would be connected with significant government action undertaken in response to the spread of COVID-19. So, for example, the request for individuals to avoid non-essential contact and travel on 16 March 2020, followed by the order for hospitality businesses to close on 20 March 2020. However, it may be that many of the losses arising from the 20 March occurrence also arose from the 16 March occurrence. They would therefore form part of a single loss. Greggs, the insured in the Greggs against Zurich case, argued that there had been some 120 occurrences between March and December 2020. However, the judge found that the more trivial or discrete announcements, which essentially followed or didn't significantly change earlier announcements, would not be viewed as standalone occurrences. The judge determined that in addition to the 16 and 20 March events, as determined in the Stonegate decision, an occurrence would include 1, the decision on 24 September 2020 to order that restaurants close early. 2, the introduction of the tier system on 14 October 2020. And finally, 3, the second national lockdown on 5 November 2020. So overall, the judge's approach in relation to aggregation was favourable to insurers, but a significant blow for the claimants or the insureds. So just going back to the 4 elements considered by the court again, you will see on the slide now showing just a brief summary of the conclusions in relation to the elements we have so far discussed. So covered events, aggregation, and losses. You'll also see a summary now on causation. So turning to causation finally, the relevant question for the court to consider was whether losses sustained after the period of insurance were caused by the covered events occurring during the period of insurance. In essence, were losses sustained by Stonegate as a result of decisions made by the government in autumn 2020, i.e. after the policy had in fact ended, and those losses being actually caused by the earlier decision to lock down in March 2020, which had been held to trigger cover? In short, the answer was no. The court determined that the government's orders to close premises was primarily driven by current and projected cases of COVID-19 rather than previous ones. Therefore, new government actions which occurred after the conclusion of the policy period were caused by the cases occurring at the time those actions were taken, and not due to those which had occurred sometime earlier and during the policy period. This finding severely restricted the losses which the insureds were able to recover. So, in conclusion, and touching now on the takeaways from these decisions, these are included on the screen, but in short, all 3 cases were fact-specific with different policy wordings. But do remember to take heed of the issues above when considering adjusting business interruption claims or losses. An appeal against the Stonegate judgment in particular is currently on the cards, although we do not yet have a date for that. But for now and at present, I think these cases represent a significant win for insurers. So that's it for me on business interruption, but I will hand over to my colleague, Tim Hornby.
Thank you, Shaira. Can I just interrupt there briefly? I've just been reminded that I forgot to invite people to ask questions. Please do so in the question and answer box. And my colleague Harriet Strevens will collate them for us to try and answer at the end. Also, one should have said that slides will be sent out after this and a recording will go on our website. Over to you, Tim.
Thank you, Andrew, and good morning, everyone. Right, so today I'm going to talk about 2 cases. Both revolve around insurers exercising rights of subrogation. Firstly, I'm going to talk about a recent High Court decision in the Rugby Football Union, from now on the RFU, versus Clark Smith Partnership and FM Conway. That case focused upon the tricky issue of co-insurance. In particular, whether an insurer is able to exercise their rights of subrogation against a co-insured. So firstly, we should probably go back a step or two, back to the basics of an insurer's right of subrogation and a fundamental limitation on that right. Where an insurer has paid out money to an insured, common law provides that the insurer is able to step into the shoes of their insured to pursue the third party that caused some or all of the loss. One very important limitation on that right, though, and key in this particular case, is that where an insurance policy is taken out in joint names, the insurer has no right of subrogation against the co-insured that caused a loss, providing that the parties have the same extent of cover. That said, how this restriction applies will depend on the full interpretation of the policy and the contract between the co-insureds. It is the same extent of cover element that was important in the RFU case. The relationships between the parties is noted on the slide you can see on the screen, with a diagram to help you follow along as I discuss the case. So the RFU commenced a project to improve Twickenham Stadium. They took out a project insurance policy for associated losses. The RFU was the principal insured on the policy. The policy also extended to RFU's contractors and subcontractors engaged with the provision of goods and services on the project. This was a blanket inclusion rather than individually naming each contractor. So the RFU took out the insurance as agent on behalf of any contractor or subcontractor. The benefit, therefore, of any cover a contractor would have was born out of the contractual relationship between them and the RFU as their employer. In simple terms, by entering into contracts with the RFU to carry out work on the project, contractors and then their subcontractors would automatically become an insured of the policy. Importantly, the policy excluded liability for losses caused by defective design, specification, or workmanship. The contract between the RFU and Conway was a JCT contract, and the insurance requirements were set out in the Option C wording. The RFU were to maintain cover for all risks of the work, but any cover would exclude damage caused by Conway's defective work. Importantly, as a result, the extent of cover intended, which the RFU would then obtain, had been narrowed by specific amendments to the contract. The JCT was clear. There was no intention for the RFU to obtain cover in respect of the indemnity that Conway provided in the contract to the RFU for the work they carried out. Therefore, there was no intention to obtain cover for any losses caused by defects in the ductwork that they built. So in this case, the following events unfolded. The RFU engaged Clarke Smith to design ductwork for power cables. They engaged Conway to build that ductwork. The ductwork itself was then ineffective. It was damaged while being pulled through by a third party. The RFU then spent £4.4 million to rectify the works, which they then claimed back 3.3 million of them from its insurers, Royal and Sun Alliance. The cost of addressing the defective ductwork was excluded from the policy, but the cost of the damage to the cables as a resulting expense was covered. The RSA then sought a subrogated claim to recover the losses from Conway, as the damage was caused by their improper workmanship. Conway issued Part 8 proceedings to prevent the claim. They submitted that as a co-insured, they had the benefit of the same cover as the RFU, and therefore the insurer did not have a right to bring a subrogated claim. As I explained earlier, the principle is that an insurer cannot exercise rights of subrogation against a co-insured that also has the same benefit of cover for the same loss. If that applied to this case, the implication would be that the RFU and all contractors had cover for losses sustained in the contract, and therefore Conway could not be pursued for the 3.3 million RSA had paid out. The court considered this proposition and the contractual relationship between the parties. The court concluded that the letter of intent from the RFU to Conway, coupled with the JCT contract, particularly Option C, meant that there was no intention for the RFU to take out insurance that covered Conway for losses they suffered as a result of Conway's defective work. This had been carved out of the contract. As such, Conway were not insured to the same extent and in respect to the same loss. On that basis, Conway were not a co-insured for the purposes of this claim. The court therefore found in favour of the RFU and, via subrogation, the insurer. RSA were free to step into the shoes of the RFU and pursue Conway for recovery of the 3.3 million paid out. Now, the decision doesn't change the law. It's a common issue, and we're probably never going to see the end of cases of this nature because the factual elements and the contractual terms will always differ. However, it's important to know that even if there are a number of parties to an insurance policy, those parties will not necessarily all hold the same benefit or qualify for the same extent of cover. So this case highlights that being named on the policy does not automatically prevent other named parties or insurers in their shoes from enforcing its terms against you. The intention of the parties, the contractual terms, the policy itself will all determine the extent of cover and must be considered carefully. Against that background, if the intention of the parties is that all involved should reap some or all of the benefit of the project policy of insurance, the necessary amendments to the contract must be made from the outset. Failure to do so can prove very costly. The second case I'm going to talk about today is another one that involves an insurer exercising their subrogation rights. That case is QBE Europe versus Generali. Apologies for those eager to hear my attempt, but I'm not going to try and butcher the Spanish pronunciation of Generali's full name. It is there, though, on the slide for those that wish to make their own attempt. I'll leave you to that. So this case concerned jurisdictional matters, and in particular whether tortious claims, such as damage to property, can trump the contractual terms of the insurance policy. In particular, the intention of the parties and the terms agreed on jurisdiction, choice of law, and dispute resolution. The slide on the screen sets out the relationships between the relevant parties in this case and how, as I'll discuss, this is an illustration of Spanish law seeking to sell an armada through English law. QBE UK issued an insurance policy to High Definition Holding for their yacht Angara. QBE Europe later took over that insurance. The insurance policy contained an arbitration clause that set out that all disputes were to be resolved by way of London arbitration and in accordance with English law. In 2016, the Angara caused damage to undersea power cables owned by REE. REE, in turn, were insured by Generali in Spain, and Generali paid out around 7.7 million euros to REE for the damage suffered. Generali then commenced proceedings directly against QBE in Spain. They did so on the basis that they had subrogation rights, and Spanish law gave them grounds for a direct claim against the indemnity insurer of the party responsible for the loss that they'd paid out. In this case, therefore, Spanish law allowed Generali to pursue directly against QBE, which they did. Generali submitted that because their claim was in tort, they were not bound to follow the contractual terms of the QBE policy. Specifically, they were free to commence their action in Spain and bypass the London arbitration clause. QBE made an application for an anti-suit injunction in London to prevent the Spanish claim. They submitted that they had agreed to take on liability for claims only on the terms set out in the policy. That included disputes being brought in London. QBE therefore sought to stop the proceedings in Spain, as to continue them would be in breach of the arbitration clause in the policy. The English court agreed with QBE, 1-0 to England. They did so on the basis that Generali were, in essence, enforcing a contractual right born out of the QBE policy. That is, pursuing high definitions insurer on the basis that the policy gave rise to QBE's indemnity. The court agreed with QBE's argument that the right being enforced is, in substance, a right to enforce the insurance contract, and then, in turn, QBE's contractual obligations to indemnify. The right, therefore, was contractual. If Generali wished to take the benefit of the QBE policy, they had to respect and comply with its terms. In many cases, a claimant may seek to assert in the non-contractual forum, usually their home country or court, a right derived from a contracting party. For insurers in particular, this case serves as a good reminder of the importance of clarity, i.e., clear choice of law, jurisdiction, and dispute resolution clauses in insurance contracts. The decision has been rationalised on a benefit and burden basis. In short, the claimant cannot enjoy the benefit of the derived right without complying with the associated obligations to pursue that right in the contractual forum. That's all from me for now. I'm going to pass you across now to my colleague, Charlotte Clarke.
Great. Thank you, Tim. I will be discussing two cases today, which both relate to the duty of fair presentation, one of which was decided under the 2015 Insurance Act and one of which was not. So the first case we have here is the Berkshire Assets West London Limited versus AXA Insurance. This case was originally decided in 2021. However, the Court of Appeal has in 2022 denied permission to appeal. The case remains of relevance not just because it's still one of the first cases of the duty of fair presentation to be decided under the 2015 Insurance Act, but because the court, by refusing leave to appeal, affirms what is required for a non-disclosure to be material. So here the High Court was asked to consider whether an insured breached its duty of fair presentation by failing to disclose criminal charges brought against one of its directors. Berkshire had a contractor's all risk and business interruption policy with AXA. A few months before Berkshire renewed its policy, 4 criminal charges for fraud were filed against its director in Malaysia. Berkshire did not disclose this to insurers, despite having an obligation to do so in terms of the policy. So then 2020, Berkshire claimed under its policy for property damage caused by flooding. AXA denied liability on the grounds that had it been aware of the criminal charges against the director, it would not have insured Berkshire in the first place. So the key issues are whether the director's criminal charges were a material circumstance for the duty of fair presentation, and if so, and they had been disclosed, would AXA have agreed to insure Berkshire? So we know that the 2015 Insurance Act has codified the well-established duty of fair presentation. So according to the 2015 Act, a fair presentation is one which discloses every material circumstance which the insured knows or ought to know. An example of a material circumstance which was referred to in this case is the sort of catch-all example of anything which those concerned with the class of insurance and field of activity in question would generally understand as being something that should be dealt with in a fair presentation of risks. So here Berkshire argued that the non-disclosure was not material because there was no merit to the criminal charges against the director. There was no dishonesty alleged on the part of the director, and the charges against the director did not amount to what Berkshire called a moral hazard. So in fact, the proceedings against the director were actually eventually discontinued on 9 October 2020, which is after Berkshire made their claim. So the court held that the prudent insurer test for materiality, which is found here in section 7, is to be assessed from the perspective of an insurer and at the time of placement. There's no benefit of hindsight which is afforded to the insured in these matters. Further, insurers are not expected themselves to evaluate the merits of a criminal charge disclosed or not disclosed. Any facts which would raise doubt as to the risk are sufficient to be material. As there is no settled definition of this moral hazard concept, and the courts preferred the statutory definition of material circumstance, which is found in the Insurance Act. The court found it's well established in law that a criminal charge constitutes a material circumstance. Now, turning to inducement, this is a question of fact. So here, AXA actually had a practice note in place, which provided that if criminal charges are disclosed, the risk should be declined. There is very little wiggle room allowed by the practice note, even where there's no dishonesty or impropriety on the part of the director facing charges. So under its practice note, AXA therefore had no authority to write the risk. The court then was satisfied that if the charges had been disclosed to AXA and the mitigating factors explained, AXA would still have declined the risk, as they have now done. So on an application for permission to appeal in 2022, the court held that while this would be the first case to consider issues of materiality and inducement under the 2015 Act, this is still not a valid reason for granting permission to appeal. The 2021 decision and its established principles were upheld. In addition to confirming principles of materiality in non-disclosures, this case also highlights how helpful it is for insurers to have underwriting guidelines in place. Because of their practice note, AXA were able to argue convincingly that a non-disclosure was material and that they would have declined the risk had the criminal charges been disclosed to them. So the next case I'll be discussing is AK and Hecklane Bedding Limited. So this case was actually decided late in 2021. However, we're mentioning it during our 2022 roundup because it contrasts nicely with the Berkshire case in that the policy predated the 2015 Act. So we see in this case how the consequences of non-disclosure are the same, even where the outcome may seem unfair, maybe with the benefit of hindsight. So the appellants in this case were trafficked into the UK and made to work in conditions which amounted to modern slavery. One of these workers, in fact, was badly injured by an accident while at work, and this resulted in him having to have a below-the-knee amputation. So on appeal, the High Court considered whether the appellants were entitled to recover from an employer's liability insurance policy under the Third-Party Rights Against Insurers Act of 1930. I'm going to call this the 1930 Act, which places a third party in the shoes of the insured under a statutory subrogation. So I should note here the 1930 Act has now been replaced by the Third-Party Rights Against Insurers Act of 2010. However, the effect of the statutory subrogation remains unchanged under the new Act. So when the insured went into administration in 2015, the trafficked workers sought to claim on the employer's liability policy for the workplace injuries which they suffered, which they could do under the Third-Party Rights Against Insurers Act, or the 1930s Act. Insurers avoided the policy on the ground of material non-disclosure, being the insured's use of trafficked labor. So here the appellants argued that insurers were not entitled to avoid the policy once it became clear that these claims were being made by vulnerable victims of human trafficking who had no other means of compensation if the policy was avoided. It was argued that policy considerations made this avoidance unreasonable. The court considered the appellant's argument in light of the other standard or non-trafficked employees of the insured. The court held that if the employer's liability policy existed only for the benefit of trafficked or vulnerable employees, this would not operate practically. It was held that avoidance is something which by its nature takes place between an insurer and an insured. So the court considered that the criminal activity of engaging slave labor constitutes a serious and material non-disclosure. As between the insurer and the insured, it was reasonable to avoid the policy. The courts also considered how much time and attention had been given over the years of academics, commenters, the Law Commission, the FCA and Parliament to defining the rights of third parties to claim on a contract of insurance and to addressing the limitations which might sensibly be placed on insurers' right to avoid. None of the legislative changes have affected insurers' rights to avoid for non-disclosure. None have expanded the rights of third parties. This is regardless of the circumstances of the third party. So the effect of the statutory subrogation under the Act is that the third party claiming has no better claim than what the insured themselves would have had, no matter the circumstances and no matter that the outcome may seem unfair to victims of criminal activities. So the policy was validly avoided, and as the insured would have failed in any claim under the policy, thus the appellant's claim must also fall. Both of these cases mentioned previously highlight that the established rule of law is applied, even when these results might seem unfair or might leave an insured or a third party with no right of recourse. The duty of fair presentation of the risk is a fundamental principle of an insurance contract, and it needs to be upheld as such.
Andrew, I think you're on mute.
Well, yeah, well, thank you very much, Charlotte. I see some questions have come in that should have been answered on the way. Harriet, have you received any?
Yes, I have actually. And if I might start with Charlotte, because you've just finished. and it's important to do so. What do you think of the outcome of the Hick Lane bedding case? Do you think there's a possible situation where the outcome could have been more fair to a third party or to the third party claimant?
Thank you, Harriet. So I must say that I agree with the judgment on the Court of Appeal. Unfortunately, while we do always want the courts to protect our vulnerable members of society, I mean, ultimately, it's just as important to, as I said, uphold the established legal principles. So insurers need to know what they are underwriting. They need to know every potential third-party liability when placing these policies. Otherwise, it would just make the risk uninsurable. It's just not commercially viable, unfortunately. So in my opinion, these restrictions placed on the right to claim are actually reasonable, even where it comes with an undesirable outcome. It was actually discussed in the case. So the fact that the appellants, being the trafficked employees, have no recourse as a result of the avoidance. The court said that the real issue here is the rules of the Criminal Injuries Compensation Authority, which limits the compensation which the appellants are entitled. So there, I think they would find really the recourse would be in a criminal injuries compensation claim, but unfortunately their rights to claim under that scheme are limited. And I think maybe that's something that requires further legislative changes. But as far as the insurer goes, their right to avoid, it was fair for them.
Yeah, fair enough. I suppose the criminal compensation issue is for another day, I guess. But thank you very much for that answer. And Shaira, I wonder if I can ask you a question. We've had many in relation to your presentation, but just briefly, one is, when loss adjusting and calculating the indemnity under the policy, exactly how would insurers differentiate between furlough payments the insured has received as against savings made on business rates?
Yeah, no, thanks, Harriet. That's a good question. I think this was addressed in Stonegate because it was left unanswered by the FCA test case. So essentially, like I said in my talk earlier, insurers had to give credit for both furlough payments and savings made on business rates, but furlough was treated slightly differently than business rates because furlough payments, they were deducted from loss calculations because they were seen as savings within the meaning of the savings clause in the policy, or on the basis that they would otherwise be a form of double indemnity, as I mentioned earlier. Business rates relief, it was slightly different as it depended on the accounting treatment of the relief. So for example, if an insured company, business rates would have been paid out of the insured company's turnover, then business rates relief would fall within the savings clause of the policy and would be taken into account when calculating an indemnity. But on the flip side, if business rates weren't payable out of turnover, then the position was different because the savings clause wouldn't apply. I think the judge in Stonegate did say that this was obviously open to interpretation and argument. So again, a little bit of an unknown. And I think something that probably will be considered on appeal. I think, though, all in all, furlough payments definitely had to be deducted, but business rates, it was fact specific. I can see that there are a few other questions in the chat box, which I will double check and get back to everyone on those as well.
Yes, I was going to say, if people have not left their email addresses, perhaps they'd like to do so that those questions can be dealt with later. Briefly, Tim, one for you now. Now we're out of the EU, do you think the decision in the QBE case you talked about would have been any different pre-Brexit?
Oh, great question. Yeah, I better stay away from the politics of Brexit, the pros and cons. There isn't a vote prepared. I don't want to start a virtual war, but in short, yes, it would have been different. So this case is a good example of Brexit providing the English court with greater flexibility and power. As a result of the recast Brussels regulations, anti-suit injunctions are not possible within the EU. So that is between 2 EU jurisdictions. So previously, the courts of England and Wales were bound by those, and therefore anti-suit injunctions were only possible in respect of claims brought in non-EU jurisdictions. The relevant regulation here is not one of the direct EU legislations that have remained. So it's not remained as part of domestic English law. Therefore, the English courts are no longer bound, and as such, common law now applies to EU courts in the same way as any other. So I think this decision in this case is a very good illustration of the strength of the English anti-suit injunction as well. So much so that the courts are open to granting those injunctions if justifiable in each case, even if doing so contradicts foreign law. So it highlights the strength of feeling in English courts as well, that they will protect the operation of English contracts subject to English jurisdiction and dispute resolution.
So dare I say, very patriotic, but thank you very much for that
Yes.
answer. And I too will keep off the politics of the answer. Mindful of the time, Andrew, there's a little bit of time left. Perhaps you'd like to proffer a view on whether or not you have any predictions for the year ahead. Rather wide question, but
Thank you. Well, firstly, I see there are a few specific questions that we'll get back to you about directly and answer. But on the question of predictions, somebody once said that predicting that predictions are very difficult, especially about the future. But I might make a few tentative ones. There's a huge amount of litigation arising out of the I've got to use my words carefully, after the stranding of a lot of Western-owned planes in Russia. There are more than 400 of them. Essentially, Western sanctions caused Bermuda, Ireland, and other jurisdictions to withdraw their airworthy certificates for all of these planes, which were leased to Russian companies. In response, Russia re-registered them under a domestic register and issued their own airworthiness certificates and kept them flying. There are huge insurance coverage actions taking place all around the world around this problem. Matters are complicated because usually aircraft are insured under two policies, a hull policy for ordinary risks and a war risk policy, and no one can agree if the planes were lost, or if they were lost, under which policy should respond. It's said that there are more than $10 billion in dispute. So there's definitely one to watch for the next year and probably subsequent years. Again, related to Ukraine, there's going to be marine cargo, political risk, and other matters emanating from the region. There may be sanctions questions arising in all kinds of policies and reinsurances. But more generally, I'd say that we still really don't have many cases on the Insurance Act 2015, despite it being eight years old, and it would be nice if we can have a few more decisions on that, which would perhaps help us all clear up some of the grey areas.
thank you very much indeed. Can I ask you to retain that baton, as we are mindful of time and we're just about to run out?
Yes, so thank you. So thank you, everyone. Our time is up. Please do contact any of us directly if you have any questions about anything. Please let us have feedback after the session. Please do connect with us on LinkedIn. And our next cover talk will be in the usual short format, 15-minute format, which will be on the 16th of March, where I will be presenting an overview of trade credit insurance. Thank you very much for listening. Everyone, have a great day.